So today I'd like to talk to you about another disclaimer of onerous property case. And this is a very interesting judgment of Mr. Justice Neuberger, as he then was in 1999. And of course the case then is Mineral Resources Ltd, citation 1999, square brackets BCC, at page 422. So the case is important because of course we have a very authoritative judge sitting and hearing the facts of the case. And the facts are this: basically Cambridgeshire County Council granted a environmental waste licence to the company, so Mineral Resources Ltd. And that licence enabled the company to operate a landfill site. And along with that operation came a number of relatively onerous obligations that related to maintaining that landfill site, including, of course, keeping an eye on various emissions and potential pollution that could flow from the site. So when the company went into insolvent liquidation, as it did, and a liquidator is appointed, that liquidator gathers in all the property, of course, property being defined by section 436 of the Insolvency Act, that Paramount Airways Lord Brown Wilkinson defined all-encompassing section. So the liquidator looks around, looks at the property, and sees that, of course, this environmental waste management licence may be defined as property that could fall within both that section 436, but most importantly section 178 of the Insolvency Act 1986, namely the section that permits disclaimer of onerous property. So the questions before Mr. Justice Neuberger, as he then was, were twofold. First, could this species of property, an environmental waste licence, be property for the purposes of the Act and section 436? And then secondly, if that is the case, if this is a piece of property, could it be disclaimed pursuant to section 178 of the Insolvency Act 1986? The problem for Neuberger, and of course the liquidator, was that the Environmental Health Agency didn't want to have this property, this licence, disclaimed, the Environmental Protection Agency, I should say. Why? Well, because of course to do so would place the burden of the management of that property on the state, on the Crown, on that agency of the government, the Environmental Protection Agency, instead of remaining with the company. We know at this stage the company is insolvent, so that in essence the burden of this liability to maintain the site and the licence and adhere to its terms is the responsibility of the unsecured creditors. Hence why the liquidator is trying to disclaim, because in so doing he can bolster the amount of asset value that is available for those unsecured creditors. So the competition then is, on the one hand, the environmental protection statutes, and in particular section 35 of the Environmental Protection Act 1990, versus the insolvency statutes, and in particular statute and the section 178 provision on disclaimer of onerous property, that would allow that liquidator to rid the company of that burdensome contract and therefore expedite the liquidation more quickly and effectively. That being one of the major purposes, of course, of the disclaimer provisions. So, in other words then, Neuberger has to decide which statutory provision wins out. Should it be the Environmental Protection Act section 35, or should it be section 178 of the Insolvency Act 1986? Well, Neuberger, in a long and exhaustive judgment, goes through the various provisions and some ancillary issues and comes to the conclusion that in this instance the Environmental Protection Act provisions win and cause, of course, then therefore the liquidator to not be able to disclaim this property. And Neuberger says that it appears to me that there is considerable public interest in the maintenance of a healthy environment, and in the principle pithily expressed as the polluter must pay. It is the view which prevails both in popular perception and in the legislative system in this country, and indeed in most of the developed world. It is not merely apparent from the provisions of the 1990 Act itself, but also from various EC Council directives. He goes on the other hand, while I accept that the provisions of the 1986 Act relating to winding up and disclaimer are not merely for the benefit of individual shareholders, creditors, debtors and liquidators of companies, but also for the good administration of business and commerce, it appears to me that those interests are of less wide-ranging and important nature, both in the domestic sense and in the international sense, than the concerns embodied in the 1980 Act. So then, with the competition between those two statutory regimes and the tension and the effect that those two statutes are trying to achieve, Neuberger comes down on the side of the environment. In another insolvency short, we will consider a later case where Neuberger again sat at first instance, Celtic and Bluestone, conjoined appeals that go up to the Court of Appeal and come before Lord Justice Morritt, where a different view is taken between that competing set of provisions. So until then, have a good read of Mineral Resources Ltd and think about those competing interests until we get to Celtic Extraction. Until then, I bid you goodbye.